Nice to see you. Happy Friday. Robert Thomas, I am so glad you're here today, Robert Thomas. We have a dog, the first, I think, dog picture that actually rivals your dog pictures. So we're going to jump right in. Hi, everybody. Sorry, I'm just talking to Robert, but just as an aside, it's nice to see everybody. Happy Friday. Really great to see everyone. We're getting some decent weather before you all hit the beach, hopefully for the weekend or the Poconos or wherever you go. Fran McGovern again. I'm here with Mike Palulek as usual. He doesn't have his camera on, but he's on audio because he's in the car. And then we have a special guest star. I got Mitch Frumpkin out of retirement to join us today. The illustrious Mitch Frumpkin. He's a legend in his own time. He is retired now. His son Seth. Mitch founded Kipcon Engineering. It's one of the prominent engineering firms, leading engineering firms in the industry. And now his son Seth has taken over and Mitch has retired. But Mitch is coming out of retirement to talk to us a little bit today on the proposed amendment, the reserve funding law, and the good, the bad, the ugly. And if anyone has any questions on that, it's always nice to have Mitch to comment on this because Mitch is very, very, very closely involved in the legislation in New Jersey and also at the national level on reserve funding standards. Mitch contributed quite a lot to them in helping write them. So it's great to have Mitch. And Mitch, thanks for being with us. And please say hi to Seth for us too. Just the preliminaries, you know this, the lawyer thing. This is annoying, but I have to say it anyway. These seminars are for general informational and discussion purposes only. They do not and cannot form an attorney-client relationship. The information exchange does not constitute legal advice. To obtain let's see, I got to click a little button here. To obtain legal advice, you got to go out there and hire a lawyer. You can either hire us, which would be fantastic. We love that. Or go hire somebody else, but you have to sign a fee letter and sign up a lawyer. So no information discussed during this webinar will be kept confidential, right? So if you put something in the chat, everyone's going to be able to see it. So if you have information that you think you don't want disclosed, please don't disclose it. Call a lawyer or an engineer or somebody else offline rather than posting it because it will go out to everyone if it's posted. So as I was alluding to earlier, I lost Robert Thomas on my screen here, but as I was alluding to earlier, we have a dog of the day shot that rivals Robert Thomas's dog of the day shot. Look at that beauty, right? Look at that shot. Somebody was a heck of a photographer. So this is River, a Bernese Mountain Dog owned by Lori Palillo from Country Creek Condominium Association. Look at the cherry blossoms she got in there. That's a beautiful thing. Robert, the two of you should get together and talk dogs because dogs and photography, because you both do great work with the dogs and with the photography. So thanks so much, Lori. Beautiful dog. Love seeing the dog. And we will figure out, we'll kind of figure out which month, given the cherry blossoms, that picture falls under for next year's calendar. So thanks a lot for submitting that. So the first bullet point we have on the agenda there is if the association is obligated to maintain, repair, and replace, the association must fund, right? They must have a reserve plan. Mitch will get into a little bit and comment a little bit on this later, but I wanted to put up there, keep in mind, remember when Mitch was back here in January of 2024 as a special guest, that is still up on our website. If you need a copy of it, that's the original legislation that was passed. And Mitch and I talked about it on First Friday with Fran in January of 2024. It's still up on the website. We're not going to get into the whole thing about structural steel and podium decks and all that other fun stuff. We're just going to talk about mainly the amendment today and kind of what changes happen. Compliance, I'm going to try to move along because this will take a long time and I want to give Mitch some opportunity to speak. So compliance or non-compliance, still no regs in place through the DCA to force compliance, right? So still no enforcement regulations in place. But it would be nice if we had, and I don't see this coming, it would be nice if we had a provision in this law that said that the act shall not form the basis for a civil claim, right? That or a civil claim or liability, that it will just be enforced by the DCA as an administrative regulation. The reason I say that is I already have one litigation in my office where the association is being sued with respect to the original reserve funding law that we talked about in 2024. And these reserve funding laws, regardless of how well intended, are going to continue to spawn litigation, right? And the litigation will spread in terms of parties. So it won't just be, I don't think, member versus association. It'll be member versus association versus board versus individual board members versus management company versus engineering firm versus law firm, right? So it would be very nice if the legislature could come up with a way to carve out civil liability claims from this statute, just so that the litigation costs and the insurance premiums that will come about increases from these types of claims will be avoided. Notwithstanding the fact that the DCA has not put regulations in place in terms of enforcement, we all know, we've talked about this before, I think Mitch mentioned it last year as well, that there are concerns regarding where insurance companies, mortgage companies, and sales prices will go if the associations don't comply, right? So if they don't comply. So if they don't comply, not only will you, at least at the current time, see potential liability from member suits, you'll also see probably insurance underwriting that is coming out with higher rates, or insurance companies refusing to underwrite your association, refusing to issue policies. If you can't have a company insure your property, you're going to have a major problem, and you might wind up in excess lines, right? You might wind up, which if you go from regular insurance companies or admitted insurance companies to excess lines carriers, you're going to wind up with your policy premiums doubling, right? Probably at least doubling. So in terms of mortgage implications, same things. If you are not complying with this, mortgage underwriters are going to look at whether or not the associations are properly funding maintenance, repair, and replacement. And they may not underwrite mortgages in your community, so people may not be able to sell. If they can't sell, they are going to sue the board, right? They're going to raise claims. Hey, you have to do the right thing here. I can't sell my house. Same thing with sales price. What are we going to see if they're not properly funded? You're going to see the sales price drop, of course, right? You're going to see sales price drop because they know if it's not properly funded, that the money's going to have to come from somewhere. And if a buyer is coming in, they're going to say to the seller, listen, I know you have a financial problem there. Why don't you take 75 grand off the price of the home, right? So that's a real issue. So that's claims based on the reserve funding law. So it can be tough, right? It can be tough. As I said earlier, who gets sued? Board members, managers, engineers, lawyers. What about the auditor? Right? Auditors don't get sued. All they do is issue an opinion based on what you told them, right? So how could anyone sue an auditor? Well, so the question is, it seems, at least with the first suit I'm involved in, the target is everyone. I don't think in that case the auditor has actually been joined, but the question is, as these suits come out more and more, will the auditors get targeted as well? I think the answer is going to be yes. So I think they're going to sue everyone and see what sticks to the wall. Are there damages? Again, we talked about this last year. Many cases, I argue, there are no damages, right? And when I say there are no damages, it generally applies to existing association members. Why? Because in theory, the money that was not included wrongfully in the reserve funding budget is still in your pocket, right? So the association goes, sorry, our bad. We're now going to come after you. Give us the money, right? So there's an argument that there is negligible damage to existing homeowners because the money is still in their pocket. Where do things get sticky? You know, I've said this before, is new purchaser. New purchaser moves in, the place isn't properly funded, the decks are found to have to be replaced, and there's a special assessment for $15,000 per unit per deck. What are those new purchasers going to say? They're going to say, wait a second, I didn't keep the money in my pocket. No. I wasn't told of any of this. I didn't know about this. And now I'm getting a $15,000 special assessment for a deck that should have been reserved for years and years and years, right? Someone's got to give me my 15 grand back because I would have knocked that off the sales price if I had known. So those people are going to be raising claims against management companies, board members, associations, etc. Keep in mind, and we talked about this before, for the realtors, I know a number of you are realtors on the call, they're also going to be raising claims against realtors, right? If this issue is known, so there's a reserve study done, it's not properly funded, it's not properly disclosed that it's not properly funded, and the seller buys in anyway, they're also going to be trying to tag the realtors. That's my opinion. So, does the business judgment rule apply such the court will abstain from second guessing the board if the board was authorized to act and there was no evidence of fraud or self-dealing? I think that's a very good argument, but within the parameters of the law. Even though the business judgment rule applies and the boards have some discretion, they still have to comply with the law as it is written, not the way they wish it was written, right? So if the law says you must have a study that provides for reserve funding in this way, they have to comply for it. If it's three option, if it's baseline funding, threshold funding, full funding, they can pick one of those options, right? But they have to pick one and they have to fund it, right? The board still has some discretion. Where does this get a little wonky? And I'm seeing this issue play out in one of my communities. And Mitch, I think, will address this too. What happens when an item, a capital item, reaches its end of its useful life before it was scheduled to reach the end of its useful life on the schedule? I'm going to keep going, Mitch, and then I'll have you jump in at the end because it'll just be easier and we can talk about all these topics. Should reserve funding law enforcement be limited to the DCA and expressly exclude private right of action? So that's what I touched on briefly before. I would love to see it exclude a private right of action, right? Because it would limit significantly associations and professionals' liability exposure, and it will be left to the DCA to enforce it. So I would like to see, I think that would be helpful. Should reserve funding laws mandate be limited to maintaining, repairing, and replacing the primary load-bearing systems of covered buildings? So there is an act, even though the act we're talking about today that is on the governor's desk has passed both houses of the state legislature, and we expect that to be signed, and Mitch will comment on that as well. We expect that to be signed shortly. There is a bill that is out there. We think the bill is basically a dead letter at this moment, but it is still out there in the session. That actually was a proposal to limit the reserve funding mandates to repairing and replacing primary load-bearing systems. So the capital reserve funding requirements wouldn't apply to things like shutters on the outside of the building or siding, things like that. We don't think that bill is going anywhere. I think it only has one party sponsorship at the moment, so it doesn't have bipartisan support, and we don't see where it's going. I think it came out of, I think it was sponsored out of Monmouth and Ocean, but we don't see the bill going anywhere at the moment. Is it as much about transparency? The reason I raise transparency is, and Mitch will address this too, there's an option if the association picks one of the three primary funding plans. There's an option for the association funding it at 85% for 5 years if the association provides a disclosure statement, and the disclosure statement form is provided for in the act itself. It's only for 5 years though, right? So it's only for 5 years, 85% of the plan for 5 years, but with the disclosure statement. So there seems to be some concern on the part of the legislature that if there is an issue, what this may really be about is disclosure and transparency, so that if someone buys into a community that is not fully funded under the plan, they are getting a notice. So the association is obligated to provide a notice of the 85% funding plan. Also provide a notice of when a special assessment or loan will be implemented to make up the 15% between the 85% of the plan and the 15% that would fully fund the selected plan. So that homeowners, buyers and sellers are aware, and it's transparent that there's a short funding here and it was part of the plan, and there will be a special assessment, there will be a loan. So once the association gives that to its homeowners, a seller in the community is obligated to give that to a potential buyer prior to the buyer signing a contract of purchase. Again, this area is going to be fraught with potential liability. I think we'll see a lot of lawsuits coming out of this because people will say the association didn't give timely notice, the association didn't give thorough enough notice, the numbers weren't accurate, the special assessment occurred earlier than they thought it would, or it was more than they thought it was, or the association had to take a greater loan than they thought it would be. All those types of things open up a significant issue, right? They open up a significant issue because you can a member or a purchaser in theory could bring claims again against the realtor, the seller, the engineer, the reserves professional, et cetera. What else? And we've talked about this in the past. What people love this law? So we love the law because it's responsible maintenance, repair, replacement, right? All this kind of winds out from the Champlain Towers disaster. We love it to the extent it requires that adequate funding of maintenance, repair, replacement must happen. It leaves a lot of question marks open though, right? Because who else loves this law, right? The banks. The banks have a lot of your money sitting in there at a very low interest rate, and they may even have the opportunity to have you borrow a bunch of money from them at a much higher interest rate. That's awesome, right? So they're sitting on a bunch of your money, and then they're charging you a bunch of money to borrow back from the bank. What about issues like snow removal, insurance premiums, litigation expenses, or catastrophic losses? Does this law mean that if you go over your snow budget by $250,000 because it was an awful winter, you cannot have an interfund balance between operating and reserve funding? I think on its face, there's an issue there that people will wind up litigating. That's going to be litigated. Same thing with, for example, a fire loss that's not immediately covered by insurance. If you have a couple units burn, can you borrow from your reserve funds, right? If the insurance company suddenly jacks your insurance premiums, can you borrow from reserve funds? I think on its face, that could be a problem. So it's a real issue. Another question, and like I said, I'm going to stop in a second and just let Mitch riff on this as well. Another issue is if there is an 85% plan and the disclosure is provided as provided in the Act, can the sponsor of a new community use the 85% plan to his advantage or her advantage during the 5 years of developer control, as long as it's disclosed? I don't know the answer to that. I don't know the answer to a lot of these questions because it's not clear under the Act. But many of these concerns and questions will be, unfortunately, worked out through the court systems, unless there are further amendments. And I also just do want to tip my hat to Mitch, Ed San George, and Dave Ramsey, who have been actively involved in working very hard to shape a reserve funding law that gets us to where we need to be. All right, Mitch, I'm going to stop for a second. I'll let you jump on in. You're good.
Can you hear me?
Yes, you're good.
Okay. Hi, everybody. Mitch Frumpkin. Just to give you a little background, first of all, as Fran said, I have essentially retired from KipCon. My son runs the business. So now instead of spending 75% of my time on CAI and 25% of the time on the business, I'm spending 100% of my time on CAI and no time on the business. So that's how my life has changed. To give you just a very quick recap, after the collapse of Champlain Towers, CAI created a national task force, which I co-chaired, which developed a public policy paper on condominium safety. That condominium safety public policy paper is used across the country for legislation, and it's very much clearly the basis for the New Jersey legislation. When the public policy came out and we worked on it, we realized that the reserve study standards needed to be changed to also include structural integrity as part of it and maintenance, which was done. I was on that committee and chaired that committee that did that. And also we realized the importance of maintenance, and CAI came out with a best practices paper on maintenance, which I was also on that task force that did that. If you want copies of any of this stuff, when I'm done, if Fran wants me to, I could drop them all into the chat box. You can have copies of them. They're all free.
That would be great, Mitch. If you could drop them, that'd be great.
So
thank you.
The legislation was approved under the direction of Senator Singleton in New Jersey, where I had the opportunity to get to meet him, spend a lot of time working on this with him. And for whatever it's worth, it renewed my faith in politicians because he's a great guy. And the legislation came out. It was approved January 8th of last year, signed by the governor, was in law in regards to structural integrity and reserves. What's happened over the last year is that more than a year, I guess it's 18 months now, maybe a little less, is that the reality of what was happening has hit the industry. And what has happened is, first of all, to keep in mind that the reason that associations are finding themselves underfunded has nothing to do with the legislation. It has to do with the fact that they weren't properly funding their reserves. It's very interesting because the legislation in the state of New Jersey requires developers to set up reserve studies as part of the governing documents and to fund them. That's required. Then once the associations take over control, there's no statutory requirements for the associations to do reserve studies or fund them. So they stopped doing it because the fees were going up. What this law does is it changed that. So now associations need to continue funding also, so they're adequately funded. But what's happened over the last year, and I'll tell you how I've seen this, as part of being involved with the Legislative Action Committee and development of this bill, whenever an association would complain to Senator Singleton or any one of their politicians, they would reach out to CAI and say, can one of you guys talk to this board and answer the question? So I have had the opportunity to see reserve studies prepared by everybody in the world, a lot of associations in regard to what's going on. And the issue is that they have not funded properly, and now they're starting to have to replace things and they don't have enough money. So what's happened is they're underfunded, special assessments, these kind of things. The other thing is that in the original legislation, it defined what adequate funding means. And and I'll talk about in a second what it means because it's been clarified in the amendment, but it talked about what adequate funding is and said every association needs to put together a plan that is adequately funded and funded. Two very important things, adequate funded and funded. So that's what they had to do. But there was not only a misunderstanding by a lot of the providers of reserve studies and boards and managers and everybody, what does that really mean? But also there were some reserve providers who said that we don't want to do it based on the definition of adequacy. We won't do it that we consider it to be a little risky. And I'll talk about that in a second. So what has happened is a lot of associations came back. Like I said, I've looked at a lot of them. Here's what the amendment says. The amendment says, first of all, it defines what adequacy is. Be very simple. What it is that if you take your reserve fund, project it out for 30 years, if during that 30-year period, at any place in that 30-year period, if it goes below zero, it's not adequately funded. If you look at the CAI National Reserve Study Standards, which I was very involved in, there's this funding plan in there called baseline funding. Baseline funding is essentially the same thing. It says that your funding plan, and baseline funding is the least conservative. It should never go below zero. So baseline funding is the definition of adequate funding in the state of New Jersey. Like I said, some providers were saying, we don't want to let it go down to zero. We will not do a study that way. We will not give the association an option of doing that. So they weren't doing that. The legislation now says that the association does not have to use baseline funding, but the reserve study has to show what baseline funding looks like from that association as a starting point for the lowest they can go. So an association can make a decision on what type of funding plan they're going to use. Keep in mind also, if you start out with a baseline funding and then you want to, and I assume a lot of people know the terminology I'm using, and then you want to go to threshold funding or full funding, any other type of funding plan, you can essentially change anytime you want. But it gives you the option and shows you specifically what baseline funding and the lowest you go is. Next thing that happened was that now it defines very clearly what adequate funding means. It says you have to include that in the study. It has to be done. But then what we were seeing a lot of is that reserve providers were doing a study, an association setting aside $50,000 a year as an example. And in order to get to adequate funding, they have to jump to $100,000. Nobody's going to do that. It's too big a jump. This was allowed under the legislation, but now it's very much clarified that you can phase in your contributions and your increases. So if you're setting aside 50, the next year you can set aside 60, 70, 80, and you can gradually increase it so it works for the association, or as long as no time in the future drops below zero. But that makes a huge difference. Most of the ones I have looked at, they're jumps. They're just big jumps. But as soon as you start adding a phasing of increases in, it works for most associations. The other thing
Mitch, can I interrupt there? So it's really kind of unclear, I think, to most people how you could smoothly do that, right? So, I think what you would describe what you're saying is close the gap. So if you if you had a reserve fund today and you said, hey, Fran, it's the association reserve fund short, I think what you're saying is most engineers would come in and say, hey, here's the 30-year plan. The contribution is going to jump from 50 to 100 over the 30-year period. And when you say phase in, how would that work again?
Well, first of all, I'll say you have to have a conversation with your reserve provider. You can't just accept the report. But if you're going to 100 immediately, you can also just say, instead of going 100, I'm going to incrementally increase it, maybe 5%, 10% a year until you get to where you need to be, but you don't have to jump.
In the
Most
in the plan over 30 years, is that what you're saying?
You can go as far into the future as you want with the incremental increases, as long as no point in the future does it drop below zero.
Within the 30-year period, right?
In the
Is that right?
30-year period, it cannot drop below zero.
Okay.
And I've worked on many of these. You can get there. You can by gradually increasing it. There's no time limit on that. There's no time limit, but you can gradually increase as long as you do not go below zero. That's the answer.
Okay. All right. I hear you.
The other thing I'll say while we're talking about that is some reserve providers include in their reserve study interest and inflation. The reason why they include people were including interest and inflation was because most people weren't updating their reserve studies. So that was taken into account. Now you are required to update them a maximum of every 5 years. So when you update it, you take into account any interest you gained and the inflationary costs. I promise you, I've seen many studies where they're including, let's say, 2 or 3% inflation. It blows the numbers out of the water. It increases it so quickly. So my suggestion is, if you're having a study done, unless you want it for some reason, tell your reserve provider 0% interest, 0% inflation, and make up for that as you're doing your updates over time. I've done side-by-side comparisons that comes out about the same. The last thing is the 85% rule, I'll call it. The 85% rule says, and I think this will answer one of Fran's questions, the 85% rule can only be used for communities prior to this legislation. If it's a new community, the 85% rule doesn't count. They can't use it. They have to go to full adequate funding. If a developer is setting up a new community, by the way, the statutory requirements in this legislation says developer still has to do a reserve study and fund it, but something new's been added. They also have to do a maintenance plan and fund the maintenance. But the point I'm trying to make is you can't, for new communities, go to the 85% rule. It's only for existing communities that are so severely underfunded, they have to do it just to get somewhere. The other thing to keep in mind of the 85% rule. Now, if you ask questions when I'm done, because I'm going into the weeds a little here, if you're going to baseline funding, it means that the lowest point over 30 years, you're going down to zero, right? You with me? If you go to the 85% rule, at that 0 point, it's going to go below zero. It's going to be a deficit. You with me? So, but as part of the disclosure that Fran talked about, it has to disclose when it's going to happen based on the reserve study and what it's going to be. Also keep in mind that people don't think about, you may reduce it to 85% for the first 5 years. As soon as you get past that 5-year period, you have to go back to adequate funding. So you're essentially kicking the can down the road 5 years to help you get there. But you are going to have to put those 5 years of 15% of dollars back in there when you update it in 5 years. So the other thing, and this is really going to the weeds quickly for a second, but I will say, the 85% rule sometimes sounds better than it is. The reason I say that, it's 85% of adequate funding. If you're very much underfunded, just to get to adequate funding, it may be a 25% increase, then you can only drop down 15%, so you're still increasing it by 10%. So there's all kinds of things. My suggestion for all of you is that deal with a reserve provider that understands exactly what it says. Talk to them. They have to understand how to get you where you need to go in a proper fashion, in a gradual way, so you're not killing yourself by trying to catch up, because it's very clear you have to fund it for adequacy and you have to do adequacy. There's no other way around it. The other thing I'll mention, and then I'll stop so you can ask questions. As far as enforcement goes, I'm very involved with what's going on with Fannie and Freddie. Fannie and Freddie have regulations. I think about 70 to 75% of loans for community associations, refinancer loans, are somehow connected to Fannie and Freddie. Fannie and Freddie say that you need to be setting aside to qualify 10% minimum of your prior year's budget into reserves. That's how they measure it. But there's also something in there that says 10% of the prior year's budget, or if there are statutory regulations in place, you have to meet them. So I think that banking requirement is really going to be a big push, that everybody's going to have to do this, or you're not getting mortgages for refinancing, because they won't let it happen, because that's a question. And so a huge amount of information. I will tell you, I don't know if I'm, and this, that next week, if you're interested, Fran, I might be there if you want. We're doing a webinar going really into the weeds and showing examples of this stuff if you want to see it. But the best way, I'll just stop and open it to any questions you might have. You could see that I talk about this in my sleep.
Thanks, Mitch. Appreciate it. And I'll jump into the questions and I'll throw them at you, Mitch, and we go back and forth. William Adler says there has been some action in Florida about limiting the reserve amounts to 3 habitable stories or more in height, and eliminating the hardship factor for less than 3 stories of residential living. What can we expect from New Jersey and from a new governor on that?
All right, well, I think we're mixing up a couple things here, because in Florida, they have regular reserve studies, and after the tragedy, they have something that's called a structural integrity reserve study. The structural integrity reserve study says that you need to fund is the structural integrity in Florida is based on 3 stories or higher. So it really doesn't relate. In New Jersey, we handle that a different way. What it says in our regulations are 2 things, and this was the original, not the amendment, because it's always been there. When you're doing a reserve study, it needs to include anything that protects the structure of the building has to be on the reserve study. So you're actually protecting the structure in your reserve study. The other thing it says is building maintenance, which includes the structure, has to be included in the reserve study. Now, keep in mind that what does that really mean, and how do you calculate it? So make sure your reserve provider knows how to do it, because it's very specific. You have to include in your reserve study a couple things: the cost of maintenance for your buildings, number one. You have to include in it the cost of your reserve study and the frequency for updating it. So if it's every 5 years, $5,000, $1,000 a year. And if you had to have a structural integrity inspection done only for certain types of buildings, which if you want, I can go off on that tangent, but you have to include the cost. No, I know you don't want to go there. You have to include the cost of that structural integrity inspection in your reserve study. And if the structural integrity inspection says anything needs to be fixed, whatever it says has to be added into the reserve study. Yeah. So there's all kinds of connections going on here, but keep in mind, every association has to do a reserve study. Yeah. Not every association has to do a structural integrity inspection. Totally different criteria.
Mitch, I think what Bill or William may have been trying to get at is, do you have a sense of anything in the future that will back down the full reserve funding for non-structural items? Do you see that backing away at all?
Well, first of all, the reserve study does not include the replacement of the structure.
No, I'm talking about things that are non-structural. So for example, like I said before, shutters, siding, things like that. Things that are required in the reserve study, and they're required to be funded, but they don't relate to the structure at all.
Oh, no, that will never happen. The reserve study is for everything, all the common elements except the structure. They all need to be in there. I don't see that ever changing.
You don't see that change. Okay. And so, because the one thing that I scratch my head about sometimes is, if God forbid we wind up in a real estate market like 1987, 1988, or 2007, 2008, I think it would put crushing pressure on the members in terms of the funding and the we'll call it the temptation to use reserved funds to fund operating through market downturns, we'll say.
Well, the legislation is very clear. Reserve funds can only be used for reserves. It's pretty clear about that.
Right.
It's pretty clear about that. So it shouldn't be used for anything except for reserves. But I'll tell you, there are many different ways to do this. For example, if you have an association with a $10 billion budget, you may say anything less than $10,000, we're not going to include it in the reserve study. We're going to take that money out of the operating budget to replace it when it's necessary. So you can do things like that as long as you note it in the reserve study that we haven't included anything less than a certain value because it will be taken out of the operating budget. I've seen
And that
that.
would have to, Mitch, that would have to be the engineers in the engineer's study. The engineer would have to put it in there.
Yes, the engineer needs to put that in the study. Yes.
Okay.
Most associations, because like if you have a common element toaster oven in your clubhouse, you're not going to put a $50 toaster oven in your reserve study. Where are you going to get the money from? You're going to take it out of your operating budget. The other thing to be very careful about is the question of maintenance. Some people may include 100% of sidewalks, but at the same time, anytime a piece of sidewalk is damaged by roots or something, they'll replace it out of the operating budget. That means you're budgeting for the replacement of sidewalks from two places. So you got to be very careful. Don't be the money in the reserve study. Just because it says the sidewalks have a 30-year life doesn't mean some sidewalks have to be replaced in 5 years and some have to be replaced in 50 years. The money comes from the reserve fund, only one place.
Right. So I'm dealing with issues now where the board is being bashed because they are repairing sections of a roadway that they it hasn't reached the end of its useful life under the reserve study, and one of the members is saying that that was improper for the board to repair the road that way. But
Well, that's like saying if the roof leaks, we're not going to fix it until the reserve study says it's okay in 2 years.
right, I mean, right,
Budgetary tool. It's
right,
budgetary.
right, and their interpretation, you know, uh, of law type concepts, that laws have to be construed or interpreted in real world reasonable ways, right? You don't do things like you just described in your example. You don't say, well, the reserve study says that the roof's going to last 25 years, so the rain has to come in until we get to 25 years. Right? That just would
Keep in
make
mind also along those same lines, if you do replace something, even if it's early, you have to update the reserve study because now you're amortizing the replacement cost over the full useful life. And it may actually reduce the amount you should be setting aside because now you've replaced it and it's brand new. So you
Yep.
got to update it when those things happen.
Irv, I think you may have already answered Irv's question, but I'll say it anyway. What about funding a deferred maintenance account that you can transfer funds as needed? And, I think what you said there is there's really no such thing as a deferred maintenance account anymore. Maintenance, repair, replacement is all included in one account. Is that right?
Yes, it has to be in the reserve study. And keep in mind, we've had a problem in our industry forever. Everybody's been using the term deferred maintenance accounts. Deferred maintenance means you're deferring maintenance. The terminology is preventive maintenance. So the term that is in all your budgets now should say preventive maintenance, which means you're actually doing something proactively.
Okay. Miriam says, how do we deal with a reserve study that lists items as past their useful life, but they are not in need of replacement? For example, our previous study said the sidewalks needed to be replaced in 3 years, but our sidewalks are fine condition, no cracks, etc. Do we still need to fund the replacement even though it's not needed?
That's a great question because I've seen a lot of reserve providers are very conservative where they don't increase the useful lives. You should increase the useful lives. If a sidewalk says 30 years and you're going to get 50 years out of it, increase the useful life. You don't have to replace it until you need to do it. You're not locked into that.
That's
And
a
the
real,
reserve,
that's a great answer, Mitch, because that is a common misconception.
when a reserve provider comes out to your site to update a reserve study, then they look at the sidewalks. If the reserve study says they have 1 year left on them that you're updating and they're in good condition and they're not going to have to happen for 15 years, that 1 year should be changed to 15 years. That's all there's to it.
Right. And so, Mitch, I've had people even say, no, 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 it says it on the schedule. We have to rip it out.
No, tell them to call me.
Okay. Okay. So you're saying we're not going to rip out good sidewalks.
No, no.
I'm glad to hear that.
That's the best thing that can happen to you. You talk about preventive maintenance, you'll see them. Do you know that if you spend if you spend money on preventive maintenance, which is generally just a rough idea, 1% of your total replacement costs spend on preventive maintenance each year, then you'll get the full useful life, if not more, out of all the components, and you'll save a huge amount of money in your life cycle costs.
Great. Michael Sika says, what are the, this is a big question, but what are the professional, legal, and ethical responsibilities on firms conducting reserve studies? He knows one who was done for a builder that was woeful and remarkably underfunded.
Well, you're talking about kind of a different animal. That's a reserve study for a builder as part of the governing documents. First of all, keep in mind that the legislation that's in place for years now say that the developer needs to include reserve study and fund it in the reserve study, fund it during their control. It also says the developer is required to update the reserve study if things change during construction and the common elements change. It also doesn't specifically say it, but it kind of implies that at the end of construction, before turning it over to the association, the developer should update the reserve study to reflect the as-built condition. I would say, you know, I only remember a few times in my career, and I've looked at a lot of developers' reserve studies. It doesn't happen that often that they consciously underfund it. What they do is they use people that don't know how to do reserve studies to do reserve studies. And getting back to what Fran was saying before in terms of the litigation, one of the things I kind of see down the road is now it says that the developers need to include a preventive maintenance manual in the governing documents that breaks down all the preventive maintenance and how much the cost is. But there's really no clear definition. It's kind of a gray area of exactly what that's going to be. I think that's going to become kind of a transition issue in the future.
Yep, agreed. Yeah. Bill Adler says he would like a summary of the new 2024 law. That's 3992.
I'll drop a copy of that in the chat box.
Yeah, I don't know if you got it, William, but Crystal sent out a highlighted copy of 3992 just prior to today's session, so you should have gotten that.
I just dropped a copy in of the reserve study standards.
Okay, that's great. That's really helpful. William Ferguson says, in a condo sale, the seller provides the buyer with a New Jersey standard 15-page property disclosure form. In a co-op, the co-op owns the unit and the buyer receives a proprietary lease. The buyer is a renter with a lease. How does the law affect co-ops, and shouldn't co-ops be required to provide the New Jersey standard 15-page property disclosure form? Do you want to chime in a little bit on co-ops, Mitch, if you want? If not, I can
Well,
chime
the reserve studies, the requirements for co-ops for reserve studies are the same. They're in a community association. The definition of the common areas is clearly different than a condo. But the co-ops are not excluded from these regulations.
Right, and our position is the same, that this reserve funding requirements apply. William, we don't do disclosure for, obviously, we don't do disclosure forms for co-op proprietary leases and purchasers, but we could talk about that offline if you'd like. Irv Schwartzbaum says, what about using debt financing to fund the gap, i.e. take out a mortgage to fund the gap in any reserve shortfall?
Well, an interesting question, because I've heard people say, that you're saying that if we're underfunded, we're going to take out, borrow money, so we increase our beginning balance so that we're adequately funded. It's an interesting question. I haven't heard of any association doing a special assessment or anything like that, or borrowing, unless they've gotten to a point where they need to replace something. I haven't heard of anybody doing it just to get to adequacy. They'd rather ramp it up, even if it's higher amount, because it's just a more practical way to do it, I think. But it's an interesting question. I've heard that a few times.
Yeah. William Adler says again, so there is no relief for single structure homes of a homeowners association versus a high-rise condos like the Surfside structure. And I think what you're getting at there, William, and Mitch can chime in on this, is whether or not it's an HOA or a high-rise or a mid-rise or a garden-style condo, the association has to fund maintenance and repair and replacement for the common elements, the common property, And even if the association doesn't own it, but it does maintain, has the obligation to maintain, repair, and replace it. So we have a lot of townhome communities where the homeowners actually own the townhome roof, own the townhome siding, but in the documents, they are required, they meaning the association, are required to maintain, repair, and replace the roofing and siding. Even though they don't own it, the association has to create a reserve funding plan and has to fund it. So it's not just ownership.
Yeah, that's an interesting comment because when we updated the reserve study standards in the last year or so, it used to essentially common elements that you own. Now it just says things you're responsible for, just to reflect that kind of thing.
Right. Thanks, Mitch. Bill Mosey says the accountants are telling us we cannot include maintenance items in the capital reserve study because they are not capital.
Well, then the accountant should read the legislation because
Yeah.
the legislation is very specific. First of all, when we did the reserve study standards, we didn't do them for accountants. We did them for associations. It's not meant to be an accounting document. But what we do is it's very specific. Maintenance needs to be included in the reserve study. What we do is it's in the reserve study, but it may not be lumped in with the reserve replacement components. It may be a separate page that says these are all the reserve components, these are all the maintenance components. So the accountant can separate them easily if they want to, but it has to be in the study. But it's a good question.
Yeah. So Bill, that's one way we got to the words deferred maintenance, right? Because people were conflating, I guess what you would say, accounting principles and accounting vocabulary with association reserve and management verbiage. So it's and vocabulary. So it is a little funky, and I'm not a tax attorney or a CPA, but it also may play into some tax consequences when you get into whether or not, say, for example, large expenditures increase basis in certain properties and things like that, whereas ordinary maintenance may not. Uh, Bill Mosey goes on to say, the prior law does not state what method of reserve funding developers must use. One could use a baseline funding method instead of full funding. How does that new law address this?
Oh, that is Bill, wherever you are. That's a great comment because every developer I've ever seen and I've ever worked for always uses full funding. The way it's defined for developers, it says developer has to provide adequate funding, and it defines adequate the same way I just did. So if a developer wanted to, they could use baseline funding and go down to zero. But every developer I've seen uses full funding because things change during construction, and then it gives them the ability to make modifications and still not be inadequately funded. But I don't, Fran, I'll also make a comment. I don't know what your thoughts on this are, that if a developer includes full funding in the governing documents, which is much more than adequate funding based on a definition, what standard you hold them to during transition? Do you hold them to the standard of full funding or adequate funding? Because that I've seen that come up a few times. But you're absolutely right that the developer can go to adequate funding and bring it down to zero. I've never seen one do it.
Right. So the the law that we're talking about right now, or the proposed law, the bill we're talking about right now, doesn't mandate a particular choice of the three. It doesn't mandate a particular choice of the three. It just says they have to be out there and you have to select one and fund one. I would strongly argue that if a developer says, hey, we're setting this up as a full funding or a threshold funding of 25% or 50% or whatever it is, that the sponsor, the developer has to follow that. So if that makes sense, right? If in a disclosure statement, which that's what a public offering statement is, if a sponsor makes a commitment that things are going to be a certain way, they're going to have to fund it that way and set it up that way.
Yeah, what I've told developers is that in your governing documents, you should say we've used full funding, even though it's much more than adequate, and we're being more conservative or something like that. So, but
Yeah, I mean, my guess is that you will see some developers go to baseline funding, right? Because then in certain respects, especially to people who are not used to the industry, it will make things look somewhat more affordable, right? Because in theory, the budget will be lower, right? Whereas full funding in theory would be a lot more, right? So your budget would look different. I tend to be on the conservative side. I like to see funding of reserves, but so I lean towards threshold. I lean towards full funding, but many homeowners, as you know, do not, right? And it's many homeowners just don't have the resources to place that chunk of cash with the association. So it becomes very challenging.
Yeah, I think that from all I've seen, full funding is essentially overfunding, baseline funding is underfunding. You need to come up with a threshold that makes you comfortable. Some people use 5% of the total replacement cost, others use 10. But most associations, when they get updates, are using threshold funding, which is more than adequate funding based on the definition. And
Yep. So let's see. James says, do civic associations require a reserve study? So James, it would really depend on what you mean by civic association. So if you'd like to, you could shoot me a note. It really depends whether your civic association would fall within the definition. Irv says the point of debt financing or a line of credit allows for no need of a special assessment and to fund through perhaps a slight increase in HOA fees rather than a large, what we'll say, disruptive special assessment or increase. So he said, I guess Irv's point is if you can borrow, you can kind of smooth the curves in terms of funding these things. So that's the question always there is at what cost, right? At what cost? And as most people know, interest rates, especially given the recent history, interest rates are relatively high, even though in long-term history, they're not very high. Mitch, you have anything else?
no, the only thing I'll mention is that keep in mind that the legislation said when it went into effect last year that if you don't have a reserve study, you need to do one within 1 year. You passed it. If you have one that's more than 5 years old, you need to have it updated within 1 year, which you passed it. And if you have anything that is less than 5 years old, you still have to update it by the time it becomes 5 years old to meet the legislation. So a lot of reserve studies have been done in the last year. And if you ever have any questions, you feel free to reach out to me.
One thing, Mitch, that I don't know that we touched on. I don't see anything in the I don't see anything in the law that prevents an association from having a study done or updated every year or every 2 years,
No,
every 3 years.
not
I
at
mean,
all.
there's a minimum of 5 years, but I've heard some criticism of associations who have done it in shorter amount of times, and right, there's no prohibition on that, right?
No, as a matter of fact, the best practices in the CAI best practices policy manual says that best practices is 3 years. The legislation says 5. And I will tell you that when we do reserve studies, as well as most other people, depending on the age of community and things like that, the reserve study is required to make a recommendation based on that community on when it should be updated. It's very rare that it's 5 years unless they are so fully funded that 5 years is good. Generally, it's based on 3 to 4 years.
Yeah. David Carroll says the problem with full funding is that people think it means 100% funding when it's really about 21%, which is much closer to 5% or 10%. I think what David's there is saying in today's world, I guess, when me and you, Mitch, talk about full funding, in the context of this legislation, we're talking about full funding of the plan, not full funding as a term of art on one of the options.
Great description because that comes up all the time. And you're absolutely right. They should be full funding based on their plan. Even if it's baseline funding, they should fully fund it. Full funding means 100% funding everything.
Right,
The,
right.
the
So that's
terminology is kind of, there's different ways to interpret that, the full
right.
funding.
Right. It can be confusing. So when someone uses the term full funding, ask them, what do you mean? Do you mean full funding as an option for one of the plans, or do you mean just fully funding the plan we have? Yeah.
Great point.
Okay.
Even
All right.
Kevin woke up for that one.
All right. Well, it's great seeing everyone. Have a fantastic weekend. It's still July. It's still summer in New Jersey. So I hope everyone gets out there and hits the beach or hits the mountains. Have a great weekend, everyone. Good to see you, and thanks for attending.